So good afternoon or good morning, depending on where you're joining us from, and a warm welcome to this BioWednesday webinar on the topic of creating and defending sustainable value in life science IP. I'm Alicia Gallier, Business Development Manager at One Nucleus. So very pleased to be welcoming you on behalf of One Nucleus. And just to say, we are doing this in collaboration with corporate sponsors Fish and Richardson, and joined by Chad Shea, who is part of the panel and a principal at Fish and Richardson. So I will shortly hand to Mike Ward, Global Head of Life Sciences and Healthcare Thought Leadership at Clarivate, who has kindly agreed to moderate our session today. And he's also joined by Emma Hodge, Head of IP at Small Pharma, and Michael Murray, Principal at Murray International Partners. But I understand the panel will be doing their own short intro, so I won't spoil that by saying anything ahead of time. So it's just my job just to give a quick update on housekeeping. So you will have heard we are recording the session, so the benefit is we can share that post the session in case you want to catch up on any of the discussion. I will be hosting it as part of our on-demand content. If you have any questions, then the chat box is enabled. I'll be keeping an eye on that, and then I can pass those to Mike and the panel towards the end of the session. So I think, as always, we like it to be discussional. We were just saying how the panelists plan to offer their honest opinions. Don't be shy either, and we'll create some good discussion and good debate. So with that, and just to say also, if you're not on the panel, just kindly remain muted and cameras off, and that would be much appreciated. So Mike, I'm going to hand the floor over to you now to kick us off. Thank you very much.
Right, I think I'm unmuted. Thanks very much, Alicia. And as Alicia mentioned, there is an opportunity to ask questions. So if you could pop them into the chat box, that would be very helpful. Alicia is going to collect them for me, and we will turn to those at the end. And also, as Alicia mentioned, I'm actually going to ask Chad, Michael, and Emma to introduce themselves. But we'll go Emma. Then we'll go Michael, and finally Chad. So if you could just introduce yourselves and the sort of the organizations you represent, where you are in that sort of your IP ecosystem. So Emma, to you first.
Hello, everyone. So I am a patent attorney, UK and European, and I head up intellectual property at Small Pharma. I've got about 20 years experience in pharmaceutical IP, most of that in large pharma organizations, and now at Small Pharma, which is not just the name of the organization, it describes it. So Small Pharma is a fairly new but development stage pharmaceutical company. We have focused on mental health conditions, and our lead project is currently in phase 2 clinical trials, and is a psychedelic molecule which is being investigated in patients with major depressive disorder.
Hi, I'm Michael Murray, and for the purpose of this session, I'm going to be called Michael so that Mike, our chair, and I can be distinguished. I think we can be distinguished anyway.
I'm not sure
how you do that.
I've dropped off.
I work independently. I formed my own business 14 years ago to step into what I thought was a gap, and appears to be a very real gap, which is how you tie IP into business really tightly. So what I do is what I call deal management. I work with clients of all sizes who are heading for or in the midst of a deal, whether it's fundraising, licensing, acquisitions, or whatever. And the IP is really very key to that in our sector, as most of you will appreciate. And so that's the way I work. And I'm not a patent attorney. I nearly became one, but I didn't quite make that step. But I'm one of those people who really finds patents in particular fascinating, the way they work or they could work. And as I'm sure you hear from various points of discussion today, it's all about making patents work properly. That has really been the stimulus for today's session.
I think we've lost Mike, so Chad, I'll step in. So if you go ahead, then I'll step in for Mike. Thank you.
Sure. At least he froze in a very scholarly pose there, as opposed to it could be a lot worse. So hi everyone. I'm Chad Shear. I'm a partner at Fish Richardson based in Southern California, and I should probably apologize right now. It is puppy season here for the coyotes. So if my dogs go crazy, it's because we have a family of coyotes living behind the house that I can't seem to get rid of. But the more important stuff. So I've been working in the pharma space now for, I don't know, 20 something years. Probably 85 to 90% of my practice actually focuses on enforcing patents. I represent innovative drug companies who are using patents to protect their market. And I've done everything from small molecules in the HIV, HCV, oncology space, all the way up to some of the larger molecules in biosimilar litigation. Over the last, say, 5 years, I guess, I've been called in more frequently by clients, longtime litigation clients, who are looking at acquiring an asset, whether that asset is a product or another company, to help analyze IP portfolios, whether that's from a litigation risk perspective or just from do we honestly think we can use the IP that they have to try to maintain some exclusivity here. And that has certainly over the last 4 or 5 years really turned into a larger piece of my practice, just because there has seemed to be a need. So I run the gamut from helping small companies. I do have some small startup companies that, sort of develop IP portfolios, all the way to larger companies enforcing those portfolios. So that's, in a nutshell, that's me.
Thank you very much all for your introduction. So yes, I think Mike's going to try and rejoin, so I will step in. I didn't say in my introduction, actually, it's great to have the range of perspectives that we do from a litigation perspective, deal making and company. So hopefully that will create some good discussion. So we were going to kick off with the first question, which was around other types of IP. So it would be interesting to hear what other types of IP are valuable to the life science ecosystem, and when those other forms might be best employed, so aside from patents. So I'm just going to go around the same order. So Emma, can I start with you?
Sure. I would say trade secrets. I think trade secrets are very underrated and overlooked. And I think a lot of small companies have probably no trade secret policy in place. So they're not identifying and properly protecting their trade secrets. And as an indication of how important trade secrets can be, Advair, I think, is a pretty good example. So Advair is a GSK product. It's a combination of 2 drug products in an inhaler called Discus. And Andrew Whitty, who was then the CEO at GSK, many times indicated his opinion that it was going to be really hard for generics to get to market, regardless of the patent position. So I believe in the US, the patent on the combination of the 2 drugs expired in 2010. The patent on the inhaler expired in 2016, but the first approval by the FDA for a generic was to Mylan in 2019. So it's quite unusual that there's that big a gap. And Mylan's actually have admitted they spent over $700 million getting that product to market as a generic. Sandoz gave up in the US, having spent maybe a couple more $100 million themselves. And obviously, the information that was in the patents was readily available, but there were also certain elements around that product that generics really took a long time to figure out, and it took them a very long time to convince the FDA that they truly had bioequivalence for that product. So yeah, trade secrets can be a really good add-on to your patent protection.
Thank you, Emma. Do you have anything to add to that, Michael?
First of all, absolutely 100% agree. And I think it's kind of surprising that they're so readily overlooked. I mean, they're the cheapest form of IP protection because you don't have to register anything. You actually just lock things away. And it's particularly important in situations where the owner of the intellectual property concerned is manufacturing, for example. I mean, again, people tend to look at composition of matter or drugs fantastic and all the rest, but forget that actually in commercial terms, being able to make it at scale, reproducibly in maybe several different places around the world is immensely important. And that's where you can really build a lot of additional intellectual property protection into your portfolio. When I'm doing deals, I'm selling a company at the moment, and there are 2 trade secrets, absolutely astonishing. 5 companies have tried to break them, can't figure it out. And you know, just underlines what you just said there, Emma. Know-how, again, people don't really understand, I think, very often that know-how, which is not quite trade secrets, it's just kind of a skill set that goes with certain forms of intellectual property, can make the difference, especially when you're doing deals and you're licensing out your patent rights. You can extend that license to include some consultative stuff and know-how transfer and so forth. It's a great way to build your collaborative dynamics as well. So that there are a few other pieces that tend to get overlooked. Yeah, I agree.
Thank you, Michael. So Mike, welcome back. We're just discussing the first question on other forms of protection apart from patents. So just going to hand to Chad now. Thank you.
Well, I completely agree with everything that's been said. I think trade secrets and know-how are critical. Maybe I'll give a plug for the ugly stepchildren of the IP world, trademark and copyright. Trademarks can be really important, especially when you get to a place where you're talking about anti-counterfeiting. And then copyright is something we never talk about in the life sciences space for kind of obvious reasons, right? But as we get more into companion diagnostics and more into personalized medicine and more into these tools that companies are using, I'll give you a perfect example. I have a client whose therapy requires that they are monitored by a physician until the patient reaches a certain endpoint, and they have a digital device that now will signal the doctor that, okay, the endpoint has been reached, you can let this person go home. The software that is written to use that is protected by copyright. So there's copyright and trademark huge. They're not. Certainly what Emma and Michael have said is far more important. Trade secrets in a house, far more important. But those are 2 other things to think about when you're designing your overall product package.
Chad, can I just ask, there's no requirement to register copyright in the US, but the guidance I've heard over the years is if you believe you'll ever need to defend yourself, you may want to register in the US. What's your take on that?
It's a damages piece. So it's like recording the deed to property in here, what we would call the county recorder's office. You don't have to register your copyright, but if you want to be able to recover damages, you do in most jurisdictions. And it's one of those things, just forget what the law is for a second. It's going to be a jury trial, and jurors won't understand why, if it was so important to you, you didn't take the time to register it. It costs nothing. You mail it into the office. So it's more of almost a thematic piece than anything else.
Great, thank you.
So as a follow-up on that, around sort of trade secrets, etc. We've seen sort of incidences where people who have worked for companies like Genentech, etc., have ended up getting prosecuted because they've sort of taken trade secrets with them, maybe not even realizing that they were trade secrets. So how can a company ensure that trade secrets can actually be kept secret?
So this is, I think, where we come down to having a good trade secret policy in place that seeks to protect your information and your assets. So a trade secret policy should, first of all, provide education to all your staff as part of your normal education policies, along with other IP education. You should have a policy that covers identifying important trade secrets and know-how, and that gives guidance around how they are protected. So where you store the information, who has access to that information, and obviously making sure that you have good clauses in your employment contracts around trade secrets and know-how as well.
Right. Oh, thanks for that. I do apologize for dropping off. You know, the UK wants to be a superpower when it comes to the life sciences, but it's a long way off when it comes to broadband. So Emma, I froze or I dropped off when you were sort of giving your introduction. So you may have already covered this, but I was interested sort of, you described that, small pharma, it's not only a description, it's also the name of the company. And I was just wondering that, you're sort of the in-house IP lead at Small Pharma. When in a company's evolution, should they actually sort of think about having, no longer sort of relying solely upon, sort of external experts, but actually to start building their own internal capabilities?
So my firm view, having spent time in large companies doing due diligence on smaller companies where we were going to license or acquire the company, and from a stint in private practice working with smaller companies and universities as well, is that most companies are far too slow in bringing somebody in-house. And I think one of the reasons for that is it's very much seen as an expense for the company. So they're looking at, how much do we spend on outside counsel, and, how would that compare with a salary for somebody in-house? And what they should really be thinking about is, well, what added value would we have? What would somebody bring to the company? So IP obviously is a large part of a company's balance sheet. Effectively, it's what the company's value is going to be based on alongside their clinical data. And by bringing someone in early, you can put in place really consistent and aligned patent strategies and full IP strategies with the business. So when people use outside counsel, they tend to go to them when they have something they want to share. So it's like, oh, we've got this great new invention, we're hoping to go to clinic, we better go and talk to the patent attorneys. Or we might be aware of a problem, we better go and talk to them. Having someone inside is much more holistic, integrated with the business, so they know what's happening in every project team. They can advise at a much earlier point. They can avoid problems. They can identify innovations earlier, which helps to get better IP, because they can also advise on, well, what data might we need? They can monitor FTO and competitors. They can deal with trade secret policies, for example, which we've just been talking about. They can talk to the board, publication strategies, overseeing publications to make sure things don't get disclosed that shouldn't be at a point where they shouldn't be, ensuring records are all in place, so that, when you come to doing deals, you're ready for that due diligence. An internal person can really be aware of all of those things and provide a huge amount of added value to a company. So I would say do it as soon as possible, really. And Chad, having been in the litigation side, I don't know if you've got anything to add to that.
I have a ton to add to that, but I can go. Looks like Mike is frozen again. Yeah, so I just add a little bit to it. I guess two big things. Big thing number one is you really can't underestimate, I'm not sure what the right phrase is. You really can't underplay how important the role of an in-house counsel is to the discovery of innovation, to the realization rather of innovation. I have never, in the however many decades I've been doing this, I've never talked to an inventor who tell me, well, I didn't really invent anything. Most inventors don't think that what they've discovered is actually patentable. And my guess would be that small companies who don't have somebody inside probably miss 20 to 30% of their patentable inventions because they just don't realize that they are. And there can be huge value in those if you spot them. The other thing I would say, as a person who has been outside and doing litigation for all these years, you only hire outside counsel for one of two reasons. You either have a need, a specific need of whatever expertise that person, he or she has, or you don't have the capacity in-house for it. Those are really sort of the only two reasons. So really, outside counsel in some ways, think of them almost as a rental. And you're renting a portion of their brain or a portion of their time, along with the other 27 clients who are renting a portion of their brain and a portion of their time. And so they're not going to be able to give you the 100% commitment, no matter how diligent they are, no matter how focused they are, how much they care. They're not going to be able to give you the same 100% focus that someone in-house would be. So I agree with you, Emma, wholeheartedly. The sooner, the better.
Yeah, I endorse all of that. I have to say, the number of times when as a deal maker I'm brought into the company when they think a deal can be done in the next 3 months, and you say, we should have been planning this 18 months ago. What's your IP estate looking like? Oh, it's great. It's great. We've got this fantastic patent. And it turns out it's a patent application. It's not a patent. It's got no legal force. It's not covering the right territories around the world. It's actually not quite aligned with the product they think they're about to license the rights in, and so forth. So I think you said a key thing there, Emma. It's seen as a cost. And I always say to my clients, if you think something's a cost, you either don't understand your business, because your IP counsel is an investment, it's not a cost, or you really don't get it at all. That you look at what drives every deal value in our space, it's IP and data. The data is an easy thing, people can get excited about it. I think IP is very often seen as something that's referred to, oh, it's a bit boring. We'll get to that. And before you know it, a year and a half has gone by and the company suddenly upped its armpits in an issue, or possibly heading into a deal with really no good chance of getting through and getting out the other end, because things are just going to fall off as they go through.
And just to add to that, having somebody in-house will help you get things right from the beginning. And it's always far more expensive and difficult to put them right later.
Yeah.
So yeah, it's a saving on what it could cost later as well.
And I think one of the things to bear in mind is, startups and spin-outs are a huge engine in the industry, but a lot of them don't make it. They fail and people move on. And I'm just circling back to one of the original aspects of Mike's sort of comment to us, which was, how do you protect stuff if people are moving on? We have to recognize, even in a healthy state of the industry, people move around companies a lot. And we need to make sure that whichever company they're leaving has really protected its own stuff and made sure that people leaving go through an exit interview where they're reminded of their obligations on their employment contract, they're reminded of their duty of care to the IP in the company they're just leaving. And, it's not impossible that they were hired or headhunted in the hope that they'll take something juicy from one company to another. So, these are things that go on. And I think there's a whole education which still needs to be done, and it's very often missing.
Thanks, guys. I think, Mike might be dropping off and on. So we've covered the first question in the chat. There was another one, a couple more that come through. So I might just jump to those if that's all right. So there was a question that said, how do you patent know-how as opposed to the molecule?
Okay, so I think know-how and patents are two separate things. So patents are, as it sounds like you're aware, it's you file an application with the Patent Office, it will be published. They're a great way of protecting inventions. But there are other things that go alongside that invention. So Michael talked about manufacturing know-how. You've filed a patent application on a molecule, for example, and you've put into that patent application a way of making it, and that was the way that the chemist made it on a small scale. But now you're going into larger scale pilot manufacturing, and you've come up with some new methods. You may not think they're patentable, but they are important. So that's the kind of know-how and potentially trade secrets that you want to identify and ensure that you protect by keeping it secret. So you really need to identify not just what is patentable, but what is also important that you want to keep secret.
One of the things you can do with know-how, I encourage clients to do this, is to build a know-how register. In other words, record in written or machine memory way what the know-how is. And it's essentially a protocol, or it's a procedure, or it's some magic that you do when you're scaling up. And then that is something which is licensable anyway. But you've also got, in terms of going into a transaction, you've actually got something semi-tangible there, which is that record. I was working with a client many years ago, and they said, we've got no IP, which I think everybody in this panel would say, no such situation. There's always IP. It's just a matter of whether it's good or valuable or whatever. They had no IP, meaning that they hadn't created any of their own patentable technology at that stage in time. They were using a nanotechnology to represent drugs in a way that made them easier for patients to take. And that was where the value proposition was. They had a lot of know-how, and they had licensed in rights from a third party. We went through what they were doing, and over a space of 4 years, they built out an enormous amount of know-how, to the point that by the time they had a product, the product was distinguishable from the product that was made under the original license that they got from the third party. And when we actually looked at what they'd done, they had a patentable sort of output. And it was then just a question of whether they retained that as know-how in the register and didn't publish it, because you publish everything eventually when you go through a patent application, or they went down the patenting route. And it comes back to commercial strategy always in my head. So there are times when you decide very deliberately not to publish or publicize certain things, and there are times when you might choose to do so. And again, I think it comes back to having a good in-house counsel. They will help you steer your way through those decisions.
Chad, did you have anything to add in addition to
that? No, not really. I think I'd probably be repeating the points that had already been made so eloquently.
In that case, there was a Mike, we're just going through some of the questions in the chat, so we're on the last one now. So Miranda asks, how can startups move from being reactive about IP to being proactive? So I'm going to throw that out to the panel, and then Mike, I'll hand back to you. We've just covered the in-house IP question. Thank you.
So I think it comes down to get some dedicated IP support as soon as you possibly can. You know, if you're not at the stage where you think it justifies taking somebody on full time, you know, can you get somebody in part time? Can you use a consultant who's going to spend a day a week for you? Something like that, so that you have somebody who's really overseeing everything, rather than somebody you just go to when you think you've got a need or a problem.
Okay, so the question I have is sort of what are the most common sort of pitfalls, either when people are sort of thinking about trying to develop a robust IP strategy, or also when you're doing the due diligence for a potential transaction, what are the sort of the red flags that people should be making sure that they haven't got those pitfalls or those hurdles in what they're doing. Chad, can I go to you first on that one?
Sure. It'll actually be really interesting. I'm actually looking forward to hearing Michael and Emma's comments on this, because I think they probably come to it from a different perspective than I do. So for me, a couple of red flags. The biggest, obviously, the no-brainers are, do you actually own what you think you own? Do you actually have the freedom to operate that you say you have? Those are always, everybody knows to go look at those. The things that scare me when I'm looking at, and I'm always for me personally, I've always been in the context of looking at someone else's assets that we want to buy. The thing that always scares me is when I can't discern what the strategy was behind the IP. It may not be a strategy I agree with. It may not have been the way that I would do it, but I'd like to actually see some sort of active thinking as opposed to we're just going to throw it all against the wall and see what happens. Yeah. Because what scares me when I don't see a strategy is it leads me to ask some other questions like, do you actually understand the market you're going into? Do you actually understand how this product is going to be used, how it's going to be marketed, who your end user is, and what the threats are in the future, whether they can be competitive, regulatory. So I always look for, the biggest thing I look for after freedom to operate and ownership, the biggest thing I look for is strategy. And a lot of times when I'll be given a chance to talk to the IP counsel on the other side, I can't ask them, why did you do this or why did you do that? That's all privileged. They're not going to answer. But a lot of times I can get at, what's your high level approach? Explain to me without any sort of specifics that would divulge some sort of attorney-client privilege. Explain to me how you approach the problem or what your goals are. And what I want to see on the other side is an active mind who has actually sat back and thought about it a little bit. And when they can't answer those questions, when I get sort of a blank stare back at me, that's when you sort of pull the client into the hallway and say, okay, we may have a problem here. We need to do some more digging. So.
Emma, do you want to have a stab at that, sort of pitfalls or red flags?
Yeah, so having spent most of my career in large pharma doing due diligence on probably smaller companies, I've been in the place that Chad has many times, and I would agree. I would say in terms of IP due diligence, if you're at a relatively early stage in a product development, which in pharma deals you usually are, we're not normally phase 3 clinical trials or marketed products. It's much more frequently that it's phase 1 or even preclinical. Most IP problems can be fixed. So even entitlement, if it's looking a bit dodgy, you can try and fix it. You can go and talk to the people who you think might have rights and try and get that all dealt with before a deal goes through. FTO, if it's a serious problem, can't be fixed unless you go out and buy that company too. So, FTO is the one thing that would kill a deal if it's a really serious one. I mean, quite often, again, you're at an early stage, so it's a potential FTO, in which case I would be looking for, have you got a strategy? Exactly as Chad said. Have you identified the risks, and do you have a strategy in place to deal with them and to mitigate them? Because that's exactly what an in-house attorney in a larger company would be doing. So what I'd say to small companies is do due diligence on yourself before you get into negotiations and a deal, because somebody else will do it. And it's much better for you to identify the problems, to identify strategies to deal with them. And then when somebody comes says to you, well, there's a bit of a gap here, we're a bit worried about this, you can say, yes, we're aware of that, but we have a strategy to deal with it, and this is how we think it will play out. And they will be much more comfortable to know that you've thought about it and you're dealing with it.
So Michael, sort of, in a sort of slightly, almost the same question, but a sort of slightly different angle. So what are the sort of specific deficits in patent strategy or in an IP data room that can kill or seriously damage the sort of the prospects of a deal?
Just following on from the two previous contributions, it's about when you see, for example, a list of, say, 10 patent families, which are purportedly all going to be part of the deal. And you look at them and you think, well, 3 of them are nothing to do with the asset concerned. In fact, and 5 of the remaining 7 historically look like they were relevant, but the products moved on a bit. And the issue is one of the company concerned or the organization concerned not having understood the marketplace they're in. So to Chad's comment, I mean, I think the market is so important. None of us is innovating in a vacuum. We're surrounded by something we don't control, and it's called the market. And this has impact on freedom to operate. It has impact on how viable the product that we're developing right now is going to be in terms of progression and chances of being finally licensed and in the marketplace and holding a good position out there. And so the deficits for me are where there's evidence of a lack of continuity. So, IP doesn't stand still because technology doesn't stand still and the market doesn't stand still. So you've got 3 or 4 dimensions there, all moving, and you don't control much of it. You can only try to play in that space as effectively as you can. And you get more effective by understanding who you're competing with, what big pharma is looking for in terms of a product profile for the drug you might be developing and so forth. And as Emma says, the freedom to operate thing is something which I think people think of as, well, we do it once and then it's done. No, you have to return to this issue time and again. As you move forward, you might have had to change tack slightly. I won't use the word pivot, I hate it, but change tack slightly to overcome a technical hurdle which still is on the path to you having a product. So that may be a formulation thing, for example. And in doing so, you might have just moved a little away from your core IP. You may be straying into somebody else's IP domain. You just need to know what you're doing. And those are the things which, when I'm in the deal-making process, if I see those holes in the other side's position, I'm either thinking we kill the deal or we're getting a few zeros going to drop off the value here because, this shouldn't be like this. This company, this university, this small entity should be in better shape by the time they're at the table.
I mean, it's interesting. Just you're talking about strategy, or all 3 of you talking about strategy. One can imagine in a pharmaceutical company or even a biotech, they've got a kind of a sense and they understand their marketplace, etc. But these days we're seeing more and more deals being done directly between pharma and sort of universities, etc. So, given the fact that tech transfer offices are sort of a key stakeholder in this, what are the specific challenges that they face in this space? Chad.
So the reason Michael and Emma are laughing is Mike Ward just set me up. Because this is a hot button issue for me. Tech transfer offices are in an unenviable position because they typically are budget constrained. I mean, let's be realistic. Typically, universities aren't in the business of protecting innovation. They're in the business of creating it and teaching students how to do it. And the big political power wielding individuals on any university campus are the highly accomplished professors. And so often it's these professors that drive the tech transfer office as to what they think is important, as to what they think is patentable, as to what they think is the next great thing. And all of them think they have the next great thing, but they almost never, it's pretty rare that you meet an academic who really understands the market. That's not what they do. Yeah. They're in the business of fundamental innovation. And so a lot of times the IP that comes out of these tech transfer offices just misses the mark a little bit because they don't understand the market and they're listening to these professors who are telling them this is what is great about this. And then a company comes along and says, well, it is great, but not for those reasons. It's for these reasons over here, and can we protect them? So there's that tension. The other fundamental tension that exists is the fundamental problem that university professors exist to publish, and they want to publish. Corporations don't publish anything until the product's been on the market for 3 years, and then they'll let somebody do a paper on the phase 3 clinical trial data that was generated 10 years ago. And that inherent risk in constantly publishing, while at the same time trying to protect, butting heads with the idea that you don't really understand the market you're trying to sort of innovate into, has the potential to cause a fundamental problem with the basic protection that these patents might afford. So I'm going to stop there. Mike Ward is frozen, so I'm going to kick it to Michael Murray, and because he's the one that baited me on this before we were chatting.
I would never do such a thing. So I should explain. I mean, I think this is a real issue. I've been entrepreneur in residence at the University of Sheffield in the UK for the last 3.5 years. And one of the things we've been doing there is trying to introduce the notion that if you think you've got something that's novel, before you rush out and spend 3 or 4 or 6 or 10,000 pounds getting a patent application together, why not have a little look at the market? And as you say, Chad, to academics, it's like, well, what are you talking about? This is brilliant work. I'm the emeritus professor of biophysics, and I published in 210 journals, and that's all true. And your science is fantastic. But the difference between good science and a good commercial opportunity are two very different things. And that's the key message that just doesn't quite get translated. And so what we've been doing at Sheffield for the last 2 years is we've been using early career researchers working with me, and we've done market analysis before the university makes a decision on filing certain patent applications. And it's been great because we've actually avoided one very expensive filing, which would have gone nowhere. There is no commercial opportunity. It was black and white. Very neat stuff, very, very innovative, but no place in the market for it. And that is a massive challenge. And related to that, when you've got these patent applications that are pumped out at very short notice, because Professor of Biochemistry is about to give a plenary talk in Hamburg, usually in about 48 hours. I did once get a call when I worked for the MRC from a guy who was at the airport, and as he flew the Atlantic to Boston, we frantically tried to get a patent application together. We did it, but it was very unnecessary. And that's the sort of thing that happens. And because it's rushed, because there isn't this reference to the market, the focus in the claims tends to be about the invention itself, which is a technical thing, but not about the commercial application that invention would be turned to. And that's the key. The claims, in my view, need to align with the direction of commercial travel rather than glorifying the core invention, if that makes sense. So yeah, it's a big one. We could rant loudly from both sides of the Atlantic here, Chad, on it, but I'm going to pass it on there.
Seeing a bit more than, oh, sorry, Emma. Yeah, okay, please go. Yeah.
So yeah, I totally agree with what Chad and Michael have said. And obviously one big tension, as I think Chad said, is that tech transfer offices are usually quite short of money. So they want to file a patent application, but they don't really want to spend any money on it, or the most limited amount possible. So they don't want to do any searching. They're like, no, we're going to file a patent application, and then we're going to talk to people and try and get some license deals done, and then we'll have money to pay for it. But if you do the searching first, you know whether you've got something that's patentable, and you can tailor your claims. And a lot of professional search companies offer fixed price searches, or you can even do a certain amount in-house yourselves. Universities have access to SciFinder and to the free patent tools. It's just a little bit of searching, so that when I've done work for universities, and we filed a patent application and we've been told, no, we don't have a budget for searching. The patent office comes back with a search, and it's 3 papers by the professors who were the inventors on the patent. And you're like, well, you should have known about those ones, really should have known about those ones. And those are some of the problems that could easily be avoided. And it would cost a lot less money in the long run because you're avoiding problems. And as I said before, problems are always more expensive to fix later.
Yeah.
Thank you all. So I think me and Mike are doing a bit of a double act. Are you okay there, Mike? You're back online, yeah?
I think so.
We were just debating the last question you asked, so it's very good timing.
Yeah, I'll set the question up and then sort of go and have a coffee. No, it isn't quite like that. So it's interesting, from the obviously sort of reading between the lines. Unfortunately, if I've been able to do that. When we're sort of looking at sort of companies and thinking about things like this freedom to operate, and do you have all your your ducks in a row? What are the data sets that you need to have access to be able to determine, you know, whether you have that freedom to operate? Is there something that is, you know, if you're a tech transfer office or a you know, small company, that you should have access to, that you should have a subscription to, or whatever? Michael, do you want to have a shot at that first?
Yeah, I think I come back to something which I would urge tech transfer officers to ask the professor, however belligerent the professor is being, which is, where do you think this invention can go? What do you think we can make with this? What does a product somewhere in the future look like? And my personal experience of doing this is highly trained, highly successful scientists say, well, you can't ask me to look in the future. We've not done those experiments yet. So it's kind of challenging. You have to get a philosophical shift going. But the reason that I would urge that is to say, okay, are we making a big, large black thing? Or are we making a small, elegant pink thing? Because they're two very different things. And therefore, the threat of freedom to operate, if there is one, is going to be different for those two things. And they may be possible starting at the same inventive concept. You can go in a number of directions. Really challenging if you're looking at an invention which is a platform. You know, a platform is presented with, we could do 110 things, and you think, oh, really? That's 110 searches. You know, that's the issue with that. So I think, I'm not sure about subscriptions exactly, Mike, but I'm sure Chad and Emma will know more about this than me. But I think have an idea of where you're setting out from when you file a patent application. What's the journey? What's the terrain you have to cross? Where are you going to end up in terms of a product? Where does that sit in the market? And then you can at least enrich your thinking for the sorts of areas where you might expect to encounter a freedom to operate issue. And I think the other thing Chad said, you know, the professor thinks he or she's got the greatest thing ever. Of course they do. They don't recognize that maybe 10 or 12 other groups around the world are working in exactly the same area, and they're coming out with something very similar. You know, just that awareness, and that's the hard part, is getting people to look away from the page in front of them and actually look up and look at the world around them and say, you know, if we make the big black thing, we're going to crash straight into that Boston biotech company that we just read about this morning. You know, that kind of thing. So I think it's a kind of general thing, and then you go from the general to the specific. That was how I look at it.
I don't know, Emma, if you would like to go, I can jump in there however you'd like to do it.
Yeah, sure. So Michael's right. Obviously, the more platform technology is a lot harder to look at. But there are some tools out there where you can at least access for free and do some basic searching around your ideas. So the World Intellectual Property Office has a database called that's searchable called PatentScope, and that has published patent applications from all around the world. So not just PCT, US, Europe, Japan, China, Korea, all over the place. And you can search with keywords, or you can draw a chemical structure, and you can do substructure searching. So if you're looking at small molecules, for example, that's a great place to start. And yeah, there are lots of commercial providers, some cheap, some much more expensive, with lots of AI behind them that make searching really easy. But as Mike said, you do need to know where you want to go, and what it is you're actually trying to search. But you can certainly do some basic searching quite easily using free tools, and that at least gives you some idea of what's out there, even if it's not going to be 100%. So over to you, Chad.
Yeah, no, I completely agree with everything that you both have said. I think the one thing that I would add is, if you're really trying to get to the bottom of whether or not you're going to have freedom to operate, obviously it's critically important to know where you're going, but it's also important to know where you came from. And so what I mean by that is sitting down with the inventor and just literally asking, where'd you get the idea? How did you come about it? Because I will just tell you from firsthand experience that has literally cost me decades off at the tail end of my life. every major lawsuit that I've been involved with, and we're talking, you know, judgments here in the billions of dollars, every major lawsuit that I've had to fight has come because it wasn't exactly clear who actually invented what they say they invented and where the idea actually came from. And I could sit here and tell stories for the next hour about that. So if you can really understand what was the genesis of the innovation, that'll often tell you, it'll get to sort of Michael's comment about, well, were you looking at the work that the other 4 groups out there were doing? How is what you did different than what they did? It also gives you a great lead on, okay, what are the patents we need to start looking at, knowing that there are these other groups out there. So that would be sort of my one thing to add.
Just to keep it in the sort of commercial sphere, I mean, and I've done this, I've worked with a client where we career towards what looks like a freedom to operate issue. But think about this, the party that owns the rights that might threaten, you know, the freedom of your opportunity to work with your product may well be very interested in your product. And so rather than seeing freedom to operate as a big axe about to just fall on you, handled right, it's actually an overture to opening a licensing discussion. And I've done that. In fact, in one case, at the MRC, when I was working there, we actually deliberately put a bunch of claims in a patent that sat bang in between 2 patents owned by a US biotech company. And we deliberately wrote the claims broad so that we would trigger a response from them when the time came. It was a good, neat strategy. We did a deal with those guys. And that was because had we kept the claims broad, we would have fallen into a freedom to operate issue. They came hunting for us straight away, of course. And we said, oh, sorry, didn't realize. And if we trimmed our claims here, would that work? Oh, yeah, that would work. But hey, what you guys doing? That looks interesting. Well, of course, you know, that was a strategy. That was a strategy of using a freedom to operate threat to actually get to the table of the company that might otherwise not have taken any notice. So I think, you know, always keep in mind that we're talking here about prosecuting IP and defending it, but at the same time, we're trying to turn this stuff into commercial outcomes, money, revenue, and so forth. And there's a few ways you can do it.
So Chad, it's interesting what Michael's saying there, is because we have seen instances where, in fact, patent authorities are now sort of striking down patents for being too broad. So how do you sort of get the balance between, you know, having that sort of muscular breadth, but not shining too much of a spotlight on yourself when it comes to sort of, you know, the patent authorities?
The simple answer is lots and lots and lots of claims of varying scope, because the reality is, and I'll raise my hand and say I'm to blame to some degree, because the 2 main cases in the U.S. where we killed patents because of overbreadth were mine. A patent prosecutor is in a very unenviable position in that you can't predict where the law is going to go. And at least here in the US, the law on breadth and claim scope, it contracts, it narrows, it's almost like a living organism. It changes. And so really what you're trying to do is predict what claims are going to survive a serious challenge, not next year or the year after, but 12 years down the road, 15 years down the road. And that's impossible to predict. So the only real way to ensure yourself that you're going to have something, at least my opinion, the only real way that you're going to ensure yourself that you have something defensible on the tail end 15 years from now is to have a lot of those somethings, so that you can peel off the ones that might be just a little too broad, or for whatever reason there's a new case that suggests that you're not allowed to do that, but you can do this. So that was strategy 1. Strategy 2, and it's expensive, but strategy 2 is always keep a patent family open. I can't tell you how often we get to a situation where we buy the asset, we're getting, we know we're going to have generic challenges in a couple of years, and we're looking at the patent family and saying, oh, why didn't they do this? Well, if the patent family is open, we can go get new claims. But if the patent families are closed, that's the end of the ballgame as far as dealing with those issues from a claim perspective. So Lots of claims, varying breadth, keep a family open so that we can try to do something later to account for the change.
Okay, I'm sure I'm not going to be the only person who's listening to you sort of thinking, what do you mean the difference between open and closed?
Michael is shaking his head. I can see he's faced this problem quite a bit too. So when you file a patent application, you're prosecuting it along, and you're allowed to file. I think in Europe they call them divisionals. In the US we call them continuations. We have divisionals too. They mean something else. But you're allowed to file continuations off of your main application that are entitled to your original priority date. As long as you have a continuation pending, your family is open, you can file new claims, you can do new things to get a new patent. The second your patent issues, if you have nothing open, if you have no continuations pending, you're not allowed to go back and file more. So that would be closed. You're done. You've gotten all you're entitled to get.
Right. Okay. Yeah. So that makes sense. We're sort of heading right close to time.
Could I just add one further strategy?
Sure,
so I totally agree. Make sure you've got claims that sort of concertina down, so you're not just broad and then your examples, but you've got all sorts of positions in between, because that's really important. But the other thing you can do for important cases where maybe you don't want to keep filing divisionals because of the cost is, if it's important, prosecute claims to something that's narrow around your actual product, and then file one divisional or continuation to the breadth, so that you're keeping something that's quite specific, is usually a lot safer, but then you go for something broader that will help you competitively in a separate application. And then the two should give you good level of protection while keeping your actual product safe.
Yeah, sounds like a good tip there. So we're right at the end of time now, and I'm going to try and keep this on time, especially as I still have some broadband. So as we sort of bring this discussion to a close, I'd like to give each one of you an opportunity to provide us with this sort of a take-home message. I mean, apart from hiring sort of like top quality, expensive IP experts, what advice would you give to sort of entrepreneurs or tech transfer offices to actually make sure that they start on the right path to protecting their intellectual property? I'll start with Michael. We'll go to Chad, and then you can have the final words, Emma. So, Michael.
Yeah, thanks, Mike. I said it earlier, know where you're going. If you were to go out and buy a motor vehicle and you bought an old-fashioned Mini and you're going to be going off-roading, you already know you got the wrong vehicle. So really think about that. Where are you going? Where do you think your deal or your exit, if you're a company, is going to happen? How do you sit in the market? So start there. And then I'm just going to keep it simple. I don't think about patents. I think about claims. Patents to me are a receptacle, a vehicle for claims. So I think we've had a really nice discussion just in the last few minutes about claims and how important they are. So think about all the claims that you would like to have in your power or your control, and start at the end. What's my final product going to look like, or what do I think it could look like, and start to really work from that vantage point.
Chad.
I completely agree with what Michael just said. I really wouldn't add too much more to it, other than I would just agree and say know the market that you're going into and have a strategy, and do some planning on the front end that it'll save you reams of headaches on the back end.
Anna?
And I would say get the basics right and document them. So I think Chad had mentioned many cases he's been involved in around inventorship and entitlement. Make sure you get your inventorship right before you file. And that is not the same as authorship on an academic paper. Ask your patent attorney to determine inventorship for you, because there are specific legal rules about it, and document it. Document why. That will then determine entitlement, who owns the patent application, and make sure that's clear and that any assignments are in place before you file. Those are really, really important.
Great. Well, thank you very much, Michael, Emma, Chad. absolutely fascinating insights and advice that you shared with us today, and I'm sure that's going to be appreciated by the audience. And also thank you to the audience members who did lodge some questions. I'm now going to hand over to Alicia.
Thanks, Mike, and thanks, Michael, Emma, and Chad, for your participation. It was really interesting, some really valuable insights from obviously first-hand experience. That's very well received. And Jess, I did see your question in the chat, so if it's okay, I'll feed that to the panel afterwards, and I'll get you a question. Sorry, an answer, an email. But thanks everyone for joining, and the recording will be sent round in the post-event follow-up. So just to wish you a good evening or a good day, wherever you are. So thanks all. Take care. Thanks.
Thank you.
Bye.
Bye, everyone.
Bye.
Bye.